Hello dear viewers. So, the first lesson on the course is Introduction to Legal Theory. The first great task of the author of a book on a subject is to define the subject and determine its scope and nature. The difficulties encountered by an author of legal theory, also known as jurisprudence, are comparatively much more than the difficulties faced by the authors of other law books. As Patton pointed out, the writer on jurisprudence is in the fortunate or unfortunate position of being able to determine the boundaries of his subject with rather more freedom than remains in other legal courses. That is why books called jurisprudence vary so widely in subject matter and treatment. If we look at modern textbook authors on the subject, especially Indian authors, they titled their works as Jurisprudence and Legal Theory. This gives rise to a question as to the distinction or the relation between these two expressions. Are they same or different? The question arises whether there is some difference between the two terms often used interchangeably by legal scientists. Such a use is evident in Comment on Jurisprudence, edited by P.J. Fitzgerald, who has used these terms varyingly. According to him, jurisprudence is the name given to a certain type of investigation into law, an investigation of an abstract, general and theoretical nature which seeks to lay bare the essential principles of law and legal systems. He says legal theory is in general an attempt to answer the question, what is law? Thus, a debate has sparked off among the jurists as to the meaning of the terms jurisprudence and legal theory. Meaning of jurisprudence. Like many other branches of knowledge, the study of jurisprudence has its origin among the Roman civilization at first. The expression jurisprudence is derived from two Latin expressions, juris and prudentia. Juris means law and prudentia means knowledge. Etymologically, jurisprudence means knowledge of law, but this meaning is vague and general. What type of knowledge it is? What type of law it is? The etymological meaning has sometimes been used to describe expositions of particular branches of law. For example, the name equity jurisprudence was once given to a textbook on equity. In a wider sense, jurisprudence is used also to describe the legal connections of any body of knowledge. So, dental jurisprudence, architectural jurisprudence, medical jurisprudence, industrial jurisprudence or environmental jurisprudence would be titles for expositions of such aspects of dentistry, architecture, medicine, industry or environment as may be important in law. It may be noted that in French legal system, the term jurisprudence has been given name to the body of law built up by the decisions of courts. Jurisprudence sometimes used merely as an imposing synonym for law, as when we speak of constitutional jurisprudence. This is not the use to which the term is put in this work. Jurisprudence is a particular method of study, not of the law of one country, but of the general notion of law itself. Law exists in every political society as binding rules of social conduct of its people. It must be interesting to inquire what exactly the nature of law is, what are its sources, what makes it binding, and what are its basic elements. The knowledge we get by such inquiry is called jurisprudence. Over a period of time, jurisprudence has been described as science of law, philosophy of law, theory of law, grammar of law, the eye of law, etc. However, jurisprudence may be defined as a study relating to law. The analysis reveals that there are many uses of the term law. Hence, one of the first tasks of jurisprudence is to throw light on the nature of law. Definition of jurisprudence. Defining jurisprudence presents some difficulties. However, attempts have been made by some jurists to define jurisprudence to determine the nature, scope, and purpose of the subject. It is suggested that the following definitions be considered at this early stage of the study. Ulpian, one of the greatest of the Roman jurists, defined jurisprudence as observation of things human and divine, the knowledge of the just and unjust. In effect, it amounts to the knowledge of right and wrong, or in other words, the right reason. Before 19th century, law was inseparable part of religion, philosophy, nature, ethics, etc. And accordingly, law was understood and interpreted as a product of reason, intuition, nature, morality, ethics, etc. Therefore, Ulpian defined jurisprudence in terms of justice, and his philosophy of law can be better understood from his famous formula which embody his concept of law, namely, to live honestly, to injure no one, and to give every man his due. He defined jurisprudence as science of just and unjust. This definition is too wide and comprehensive and includes in its scope other social sciences like philosophy, ethics, and religion, which also teach a man to distinguish between right and wrong. Jurisprudence is not concerned with the whole gamut of human relations and has no direct and immediate bearing on moral and ethical conduct of man. Austin. Austin defines jurisprudence as the philosophy of positive law. Austin meant by positive law or jus positivism the law laid down by a determinate human superior or sovereign for the purpose of regulating the conduct of the subjects. Austin says that jurisprudence deals not with every rule of action, but only those rules which are laws properly so called, or what are called the laws of lawyers and law courts. By this emphasis on positive law, Austin wanted to avoid the demerit of Ulpian's definition of being too wide a definition of jurisprudence. Austin has not succeeded in completely avoiding the demerit of Ulpian's definition. By calling jurisprudence a philosophy, Austin introduced an element of ambiguity and uncertainty as to the true scope and province of jurisprudence. Austin refers to two types of jurisprudence, general and particular. By general jurisprudence, he means the philosophy of positive law. And by particular jurisprudence, he means the science of particular law or the science of any system of positive law prevailing in any country. Austin's division of jurisprudence into general and particular has been criticized by Holland and Salmond. According to Holland, the study of a particular legal system is not a science. According to Salmond, the error in Austin's idea of general jurisprudence lies in the fact that he assumes that unless a legal principle is common to many legal systems, it cannot be dealt with in general jurisprudence. There may be so many schools of jurisprudence, but there are not different kinds of jurisprudence. Jurisprudence is one integral social science. The distinction between general and particular jurisprudence is not proper. Actually, what we are dealing with are not different kinds of jurisprudence, but the different systems of law. Holland. Holland defined jurisprudence as the formal science of positive law. It is a formal or analytical science rather than a material science. By calling jurisprudence a science and not philosophy as Austin did, Holland has clearly specified the province of the subject. The term positive law has been defined by Holland as the general rules of external human action enforced by a sovereign political authority. Holland followed the definition of Austin, but he adds the term formal, which means that which concerns only the form and not its essence. Formal science is herein used as opposed to material science. A formal science is one which describes only the form or the external side of the subject and not its internal contents. According to Holland, jurisprudence deals not with concrete details but with only generalities of legal doctrine. Jurisprudence is concerned with such fundamental concepts which are common to the most of the matured legal systems and not with minute variations that the concepts might have undergone in different legal systems. Jurisprudence is not concerned with the actual material contents of law, but with its fundamental conceptions. Holland came to the conclusion that jurisprudence is not a material science, but merely a formal science. Holland's definition of jurisprudence is criticized on the ground that it is narrow and cryptic. It is pointed out that jurisprudence is not only a formal science, but also a material science. According to Professor Gray, jurisprudence is in truth no mere a formal science than philosophy. As bones and muscles and nerves are the subject matter of physiology, so the acts and forbearances of men and the events which happen to them are the subject matter of jurisprudence. The real relation of jurisprudence to law depends upon not what law is treated, but how law is treated. Professor Gray thinks that jurisprudence need not be restricted to generalities only, and any systematic study of legal doctrine, whether general or particular, must be called jurisprudence. But Professor Gray's criticism is not in consonance with the popular conception of jurisprudence as the science of law in general. Otherwise, we have to talk in terms of income tax jurisprudence and industrial jurisprudence and also Indian jurisprudence and American jurisprudence, which is contrary to the true meaning of jurisprudence. Salmon. Salmon defines jurisprudence as science of first principles of civil law. By civil law, Salmon means the law of the land or the law properly so called or law of the state. Civil law means law of citizens or law pertaining to citizens. So, civil law is the entire law that applies to citizens of a state. It is the law that is administered by the civil courts, criminal courts, prize courts, etc. It is in such sense that the term civil law is used in jurisprudence. Salmon defined civil law as the law of the state or law of the land, the law of the lawyers and the law courts. Here, law does not include the law of the theologian or moralist, which are called laws by analogy only. By first principles, Salmon means fundamental concepts of legal doctrine. Julius Stone. According to Stone, jurisprudence is lawyer's extraversion. It is the lawyer's examination of the rules, precepts, ideals and techniques of the law in the light derived from present knowledge in disciplines other than the law. Stone says, for the study of jurisprudence, mastery over social sciences other than law is indispensable. Diaz. According to Diaz, at present, jurisprudence may tentatively be described as any thought or writing about law, other than a technical exposition of a particular branch of the law itself. If X writes a book about the economic effect on the families of convicted prisoners on their conviction, this could be called a contribution to jurisprudence. If Y writes a book on theories of justice in ancient world, this would be a contribution to jurisprudence. If Z describes the development of case law in India and the psychology of judges, this would also fall within the scope of jurisprudence. Sometimes qualifying adjectives are attached to the noun, so that the book of X might be called a study in economic jurisprudence, Y's book is example of philosophical jurisprudence, and Z's book is on psychological jurisprudence. But with or without qualifying adjectives, it would be within the province of the subject, as all the three books being works of jurisprudence. Paton. Paton observes, modern jurisprudence trenches on the fields of the social sciences and of philosophy. It digs into the historical past and attempts to create the symmetry of a garden out of the luxuriant chaos of conflicting legal systems. The breadth of its scope, covering a voluminous literature within many tongues, makes it a difficult subject to master. It appears proper to state that jurisprudence meant whatever different jurists wanted to mean. It was understood by analytical, historical, ethical, and sociological jurists in their own way. Jurisprudence covers a limitless field. Different approaches have been made, but none of them can be certainly called perfect and adequate in itself. The purpose of legal theory. The purpose of legal theory is an attempt to answer the question, what is law? It is not a simple question as it appears to be. It includes within its fold various questions such as, what is meaning of law? What is definition of law? What are the elements of law? What are the sources of law? What are the functions of law? What are the essentials of a valid law? So on. The various writers have devoted much time and energy to define the term law. The word law is rather ambiguous and leads to many confusions. This word may be used in a concrete sense or an abstract sense. In the abstract sense, the constituent elements of which the law is made up are not laws, but rules of law or legal principles. In the concrete sense, law means a statute, enactment, ordinance, or other exercise of legislative authority. Provision for definition, it may be argued, springs from the necessity of clarifying the most basic of all legal concepts, that is, the concept of law itself. If jurisprudence is concerned with the analysis of legal concepts, surely the first problem is to analyze the basic concept, that is law. It is not mere theoretical question, but one of practical significance. The definition of law has a practical legal consequence. The questions such as whether international law is law proper and whether an unjust law can really claim to be law can be solved by reference to a definition only. It may be argued that law itself is not a legal concept any more than geometry is a geometrical concept. In geometry, the mathematician calculates or operates with certain geometrical concepts such as circle, triangle, parallel, and so on. But the concept of geometry itself is not included within its framework. Likewise, in law, we find such legal concepts as consideration, possession, and so on, used by the lawyer to draw conclusions and solve legal problems. But the concept of law itself is not one that figures in legal argument or gives rise to conclusions of practical significance. No legal judgment ever hinges on the definition of law. What constitutes consideration is a typical legal question of practical significance. What is law is a theoretical question, not a question of law, but about law. This argument can be countered by another argument that how, without a definition of law, can we decide practical matters as whether international law is law or whether an unjust law is law. And these are definitely questions of great legal significance. But can it be said that lawyers and courts decide actual legal cases by reference to a definition of law? In fact, in cases of unjust law, the court may refuse its implementation because it contravenes a fundamental rule of the Constitution or because its injustice runs counter to the fundamental policy of the state's legal system. But in this case, the concept of law itself is not used as a touchstone of the legality of the legal rules. Though law is not a legal concept, it is nevertheless the basic concept of jurisprudence, and its analysis is relevant to all other legal concepts. Legal notions such as right, possession, etc. can largely be explained without reference to the concept of law. Though the definition of law may not be a strictly legal question, it is nonetheless one of considerable non-legal and political question. It is evident that a definition of law is necessary in legal theory, but to define law is not so easy. No neat and simple definition of law has emerged from various theorists because different theories not necessarily attempt to answer the same question. Some jurists concern themselves with the formal characteristics of law, others with its contents, and still others with its practical application in social background. Nevertheless, real conflict does arise. Obviously, a theory defining law as the command of the sovereign is diametrically opposed to one which defines law as a rule in accordance with right and reason. We know what law is and what rules are, but yet we find it hard to explain their nature. If law were a legal concept, it might be useful to lay down clear boundaries between what shall and what shall not count as law. The purpose of legal theory is to cover various theories of law because of their influence on jurisprudential thought in the past and their continuing influence even today. Jurisprudence and legal theory. The term jurisprudence in the Anglo-Saxon world and in former British colonies and to some extent India has a definite legal, linguistic and contextual meaning and thought content. It is an expression to denote the approach which envisages the analysis and exposition of law by weeding out non-legal value-oriented elements. Such a study is purely logical, empirical, unaffected by ends or purposes which the law is supposed to subserve. The term legal theory was coined by Friedman in 1945. The term legal theory is generally used in the sense as an evaluative and normative study of the basic concepts and fundamentals of law and its relationship with morality and justice. Legal theory is not concerned with or interested in the entire field with which jurisprudence is concerned. Its principal concern and attempt is to analyze what can be described as fundamental or core elements of the phenomenon law. But the distinction so made between legal theory and jurisprudence appears to be of semantic value and is illusory, as their contents are not only inseparable, as are their respective goals and purposes. Jurisprudence as lawless science of law. Jurisprudence is a subject which differs in kind from other subjects on the legal syllabus. For the typical legal subject like contract or tort, consists of a set of rules and principles to be derived from authoritative sources and applied to factual situations in order to solve practical problems. Jurisprudence, by contrast, does not constitute a set of rules, is not derived from authority, and is without practical application. Another point of difference between jurisprudence and other legal subjects is that the method of inquiry. The method of inquiry apt for jurisprudence will not necessarily be that used in the study and practice of ordinary or typical legal subjects. In jurisprudence, we are not concerned to derive rules from authority and apply them to problems. We are concerned better to reflect on the nature of legal rules. In law, we look for the rule relevant to the given situation. In jurisprudence, we ask what it is for a rule to be a legal rule and what distinguishes law from morality. In this, jurisprudence comprises philosophy of law. The basic features of legal system are chiefly found in its authoritative sources. Here we consider such matters as the pros and cons of codification, the value of a strict system of judicial precedent, and the methods of judicial reasoning. Jurisprudence also consists of the analysis of legal concepts such as right, duty, obligation, possession, etc. The law of contract and tort concerned with different rights which one person may have against another. Jurisprudence, on the other hand, studies the meaning of the term right in the abstract and seeks to distinguish the various kinds of rights which are in theory possible under a legal system. In all other legal subjects, we learn the law. In jurisprudence, we think about the law. That is why jurisprudence has been described as the science of law, the study of the essential principles of law, philosophy of law, sociology of law, etc. Utility of the study of jurisprudence. The subject matter of jurisprudence is law. Jurisprudence is concerned with the genesis, growth, functions, and ends of law. It is the function of a jurist to study the fundamental principles on which law is based. The importance of the study of jurisprudence cannot be undermined. It is absolutely essential not only for students of law, but also for the practicing lawyers. The study of jurisprudence enables the students of law to understand the exact meaning of the legal terms and thereby avoid loose thinking and confusion. Jurisprudence is to law as grammar is to language. As a sound knowledge of grammar is necessary for understanding a language, the same is the case with jurisprudence so far as the students of law are concerned. A thorough knowledge of jurisprudence is bound to create a better understanding of law. If our aim is to study the law, we must put due emphasis on the study of jurisprudence. It has been rightly said by Professor Lasky that jurisprudence is the eye of law. In all difficult questions of law before the higher courts, the knowledge of jurisprudence is very helpful. Both the judges and lawyers are likely to bungle and lay down bad law if they do not have a grasp of jurisprudence. The same can be said about legislators. There may not be any accuracy in legal phraseology, and that may result in endless litigation. Such a situation has to be avoided at all costs. If those who are entrusted with the task of drafting legislation have a good grasp of the fundamentals of jurisprudence, society is bound to profit thereby. In this lesson, an attempt is made to give introduction to the study of legal theory, to explain the relation between jurisprudence and other legal courses, and also the utility of its study. Thank you.